Hello students, I am Dr. Harpreet Kaur from Army Institute of Law Mohali. Today I will be discussing the topic of reservation vis-a-vis economically backward classes, a critical study. Introducing the topic, EWS reservation is a step towards economic justice and social inclusion. It is not a charity or a favor, but a right and a duty of the state. Quoted by Prakash Javadekar. Reservation is a form of affirmative action that aims to provide equal opportunities to the historically disadvantaged and marginalized section of society in India. Reservation policy in India have been primarily based on caste, which is a social and religious hierarchy that determines one's status, occupation and access to resources. However, in 2019, the Indian Parliament passed the 103rd Constitutional Amendment, which introduced a new category of reservation for the economically weaker section of the society. General category who are not covered by any existing reservation schemes. The economically weaker section reservation policy grants 10% of reservation in governmental jobs and educational institutions to those who belong to the general category and have an annual income of less than rupees 8 lakhs, own less than 5 acres of agricultural land and have a residential house of less than 1000 square feet. The policy was enacted with the objective of addressing the economic backwardness and inequality among the general category, who constitute about 50% of the population but have only 25% of the seats in government jobs and educational institutions. Coming to the historical account of EWS reservation. The historical background of EWS reservation in India can be traced back to the following events and development. The concept of reservation in India was originally introduced to provide social justice and representation to the historically oppressed and marginalized section of society, such as scheduled castes, scheduled tribes, who face discrimination and exclusion on the basis of caste. The Constitution of India, which came into force in 1950, provided for reservation for SCs and ST in public employment and educational institutions under Article 16 Clause 4 and 15 Clause 4 respectively. The reservation was initially intended to last for 10 years, but it has been extended ever since. In 1979, Second Backward Classes Commission, also known as Mandal Commission, was set up to identify the other backward classes who were socially and educationally backward and to recommend the measures for their advancement. The Commission submitted its report in 1980, which suggested that 27% of the seats in the government jobs and educational institutions should be reserved for OBCs, in addition to the existing 22.5 reservation for the SCs and STs. However, the report was not implemented until 1990, when the then Prime Minister VP Singh announced the implementation of the Mandal Commission recommendations, which sparked widespread protest and agitation across the country. In 1992, the Supreme Court of India, in landmark case of Indira Sahni versus Union of India, upheld the validity of 27% reservation for OBCs but laid down certain conditions and guidelines for the reservation policy. The court held that reservation should be based on social and educational backwardness and not on economic criteria alone, and that the creamy layer, that is the affluent and advanced section among the OBCs, should be excluded from the benefit of reservation. The court also imposed a 50% ceiling on the total reservation, stating that reservation should not exceed the limit of 50% of seat in each category, except in extraordinary situations. In 2019, the Parliament of India passed the 103rd Constitutional Amendment, which introduced a new category of reservation for the economically weaker sections of the general category, who are not covered by any existing reservation schemes. The amendment inserted two new clauses in Article 15 and 16 of the Constitution, which empowers the state to make special provisions for the advancement of economically weaker section of citizens, including reservation in the government jobs and educational institutions. The amendment also specifies that the reservation for EWS shall not exceed 10% of the total seats in each category and shall be in addition to the existing reservation. Now, coming to the constitutional and legal perspective. The constitutional and legal basis of reservation for economically weaker section in India is the 103rd Constitutional Amendment, which was passed by the Parliament of India on 9th January 2019 and received the President assent on 12th January 2019. The amendment inserted two new clauses in Article 15 and 16 of the Constitution, which empowers the state to make special provisions for the advancement of any EWS of the citizens other than the classes covered by the existing reservation for the scheduled caste, scheduled tribes and other backward classes. These articles also specify that the reservation for EWS shall not exceed 10% of the total seats in each category and shall be in addition to the existing reservations. The articles apply to both educational institution and public employment. Article 15 clause 6 postulates that nothing in this article or subclause G of clause 1 of Article 19 or clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any economically weaker sections of citizens other than the classes mentioned in clause 4 and clause 5, insofar as such special provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institution referred to in clause 1 of Article 30, which in the case of reservation would be in addition to the existing reservation and subject to maximum of 10% of the total seats in each category. Article 16 clause 6 states that nothing in this article shall prevent the state from making any provisions for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than the classes mentioned in clause 4, in addition to the existing reservation and subject to a maximum of 10% of posts in each category. The amendment was challenged in the Supreme Court of India on the ground that it violated the basic structure and the principles of the Constitution, such as equality, secularism and social justice. It was also urged that the amendment breached the 50% ceiling on reservation imposed by Supreme Court in the Indira Sahni case, which held that reservation should be based on social and educational backwardness and not on economic criteria alone. Moreover, it was contended that the amendment did not follow the proper procedure and criteria for identifying the EWS and did not provide any data or study to justify the need and extent of reservation for EWS. However, on 7th November 2022, the Supreme Court by a majority view of 3:2 upheld the validity of the 103rd Constitutional Amendment and held that it did not violate the basic structure of the Constitution. The court observed that the amendment was a valid exercise of the constituent power of the parliament and that the 50% cap on reservation was not inviolable and could be exceeded in exceptional circumstances. The court also held that the economic criteria was a reasonable and rational basis for providing reservation for EWS and that the state had the discretion and authority to identify and define the economically weaker section. The court further noted that the amendment was a progressive and inclusive measure that aimed to provide equal opportunities to the economically backward sections of the general category who had been facing discrimination and deprivation in the Indian society. Therefore, the 103rd constitutional amendment is the constitutional and legal basis of reservation for EWS in India, which has been upheld by the Supreme Court as a valid and constitutional policy. Coming to the landmark cases regarding the reservation. The first case is Janit Abhiyan versus Union of India. This is a writ petition of year 2019. The Supreme Court of India decided on 7th of November 2022. This is the landmark case that upheld the validity of 103rd constitutional amendment and EWS reservation policy by a 3:2 majority ratio. Court held that the amendment did not violate the basic structure of the constitution, that the 50% cap on reservation was not inviolable and that the economic criteria was reasonable and a rational basis for providing reservation for EWS. In case of Indrasani versus Union of India, it is a 1993 judgment, Supreme Court, page number 477. The Supreme Court of India decided on 16th of November in 1992. This famous case that imposed 50% ceiling on total reservation and struck down the 10% reservation for economically backward classes among the higher caste. The court held that reservation should be based on social and educational backwardness and not on economic criteria alone, and that the creamy layer should be excluded from the benefit of reservation. Next case is Ashok Kumar Thakur versus Union of India. The Supreme Court of India decided it on 10th April 2008. This is the case that upheld the validity of 93rd constitutional amendment and the 27% reservation for other backward classes in educational institutions. The court held that the amendment did not alter the basic structure of the constitution, that the 50% limit on reservation was not applicable to educational institutions and that the creamy layer should be identified and excluded from the OBC reservation. The next case is M. Nagaraj versus Union of India. The Supreme Court of India decided this case on 19th of October 2006. This is the case that upheld the validity of the 77th, 81st, 82nd and 85th constitutional amendments and the consequential seniority and accelerated promotion for SCs and ST in public employment. The court held that the amendment did not violate the basic structure of the constitution, but laid down certain conditions for the state to provide reservation in promotion, such as quantifiable data on backwardness, inadequacy of representation and overall efficiency. The next important case is TMA Pai Foundation versus State of Karnataka. It is a case of year 2002. The Supreme Court decided it on 31st October 2002. This is the case that dealt with the issue of reservation in private unaided educational institution. The court held that state cannot impose any reservation on such institution as it would violate their right to autonomy and freedom under Article 19, Clause 1, Subclause G of the Constitution. However, the court held that the state can regulate the admission process of such institutions to ensure merit, transparency and fairness. How EWS quota shapes India's socio-political landscape. The reservation for economically weaker section in India is a policy that aims to provide 10% reservation in government jobs and educational institutions to those who belong to a general category and have an annual income of less than Rs 8 lakh, own less than 5 acres of agricultural land and have a residential house of less than 1000 square feet. The policy was enacted by the 103rd Constitutional Amendment in 2019 and was upheld by the Supreme Court in 2022. The reservation for EWS in India has several socio-economic and political implications, such as it may increase the educational and employment opportunities for the economically weaker section who have been facing economic backwardness and inequality in the Indian society. It may also enhance their social mobility and empowerment and reduce the gap between the rich and the poor. It may affect the interests and aspirations of other backward classes, that is OBCs, who have been the main beneficiaries of reservation for decades. It may reduce their share of seats and posts in the government jobs and educational institutions and create a sense of resentment and injustice among them. It may also create a conflict between the EWS and OBCs over the issues of overlapping, exclusion and inclusion. It may reflect the changing dynamics and realities of caste and class in India and the emergence of new social groups and identities. It may challenge the traditional notion of reservation based on social and educational backwardness and introduce a new criteria of economic backwardness. It may also acknowledge the diversity and heterogeneity within the general category and the existence of multiple forms of deprivation and discrimination in India. It may have political implications for the ruling and opposition parties and their electoral prospects and strategies. It may be seen as a populist and appeasement measure by the ruling party to woo the general category voters who constitute a large and influential segment of the electorate. It may also be seen as a response to the demands and protests of the various dominant castes such as Jats, Marathas, Patidars and Kappas who have been seeking reservation or other benefits from the state. It may also put pressure on the opposition parties to take a stand on the issue and to address the concern and expectations of various sections of society. And next I will be discussing comparison of economically weaker reservation with the reservation for other backward classes. The reservation for economically weaker section and the reservation for other backward classes are two categories of reservation in India that aim to provide equal opportunity to the historically disadvantaged and marginalized section of society in government jobs and educational institutions. However, there are some similarities and differences between the two categories of reservation in terms of their criteria, scope, benefit and challenges. Some of the similarities are as follows. Both the EWS and OBC reservation are based on the constitutional and legal provisions that empower the state to make special provisions for the advancement of any backward section of citizen. The EWS reservation was introduced by the 103rd Constitutional Amendment in 2019, while the OBC reservation was based on recommendations of the Mandal Commission and the 93rd Constitutional Amendment in 2005. Both the EWS and OBC reservation are subject to a maximum limit of 10% and 27% respectively of total seats in each category and are in addition to the existing reservation for SCs and STs. The EWS and OBC reservation are also applicable to both educational institutions and public employment except for the minority educational institutions under Article 30 of the Constitution. Both the EWS and OBC reservation are intended to address the issues of educational and income inequality in India and to enhance the social mobility and empowerment of the economically and socially backward sections of the society. Both the EWS and OBC reservation are also expected to have political implications for the ruling and opposition parties and their electoral prospects and strategies. Some of the differences are: the EWS reservation is based on the economic criteria alone, while the OBC reservation is based on the social and educational backwardness criteria. The EWS reservation is applicable to the general category candidates who have an annual income of less than rupees 8 lakh, owns less than 5 acres of agricultural land and have a residential house of less than 1000 square feet. The OBC reservation is applicable to the candidate who belong to castes and communities that are listed in the central or state OBC list. The EWS reservation is a uniform and a centralized policy, while the OBC reservation is a variable and decentralized policy. The EW reservation uses the central list of EWS, which is applicable to all the states and union territories. The OBC reservation uses the central list of OBCs for the central government jobs and educational institutions and the state list of OBCs for the state government jobs and educational institutions. The state have the authority and discretion to identify and define the OBCs and to modify and update the OBC list. The EWS reservation is a new policy and controversial policy, while the OBC reservation is an established and is an accepted policy. The EWS reservation has been challenged in the Supreme Court on the ground that it violates the basic structure and principle of the Constitution, such as equality, secularism and social justice. It has also been argued that it is a breach that 50% ceiling on reservation imposed by the Supreme Court in the Indira Sahni case, and that reservation should be based on social and educational backwardness and not on economic criteria alone. The OBC reservation, on the other hand, has been upheld by the Supreme Court in several cases, such as Indira Sahni case, the Ashok Kumar Thakur case and the Jarnail Singh case. The OBC reservation has also been implemented for several decades and has gained the support and recognition of various sections of society. Evaluation and critique of EWS reservation. The reservation for economically weaker section in India is a policy that aims to provide 10% of reservation in government jobs and educational institutions to those who belong to the general category and have an annual income of less than rupees 8 lakh, own less than 5 acres of agricultural land and have a residential house of less than 1000 square feet. The policy was enacted by the 103rd Constitutional Amendment in 2019 and was upheld by the Supreme Court in 2022. The reservation of EWS in India has been subjected to various evaluations and critiques from different perspectives and viewpoints. Some of the main arguments and opinion on the merit and demerit of the policy are: the policy is progressive and inclusive measures that aim to provide equal opportunities to the economically backward section of the general category who have been facing discrimination and deprivation in the Indian society. The policy is based on economic criteria, which is a reasonable and rational basis for providing reservation, as it reflects the actual condition and need of the beneficiaries. The policy is also a valid exercise of the constituent power of the Parliament and does not violate the basic structure of the Constitution. The policy is also in line with the directive principles of state policy, which mandates the state to promote the welfare of the people and to reduce the inequalities in income and status. The policy is a regressive and divisive move that violates the constitutional and legal principle of reservation such as equality, secularism and social justice. The policy breaches the 50% ceiling on reservation imposed by the Supreme Court in the Indira Sahni case, which held that reservation should be based on social and educational backwardness and not on economic criteria alone. The policy also dilutes the rights and benefits of the other backward classes, who have been the main beneficiaries of reservation for decades. The policy also ignores the realities and complexities of caste and class in India and the existence of multiple forms of deprivations and discrimination in India. The policy is a populist and appeasement measure by the ruling party to woo the general category voter, who constitute a large and influential segment of electorate. The policy is also a response to the demands and the protest of various dominant castes such as Jats, Marathas, Patidars and Kapas, who have been seeking reservation or other benefits from the state. The policy is also a political gamble by the ruling party, as it may alienate the OBCs and the SC and STs, who form a significant part of their vote bank. The policy may also face legal and administrative hurdles in its implementation, as it may require data collection, verification and monitoring of the economically weaker section beneficiaries. Concluding the topic, I want to say that the economically weaker section reservation policy is a landmark and controversial policy that has introduced a new dimensions to the reservation debate in India. The policy has been hailed as a progressive and inclusive measure that aims to provide equal opportunities to the economically backward section of the general category, who have been facing discrimination and deprivation in the Indian society. The policy has also been criticized as a regressive and divisive move that violates the constitutional and legal principles of reservation, dilutes the rights and benefits of the OBCs and ignores the realities and complexities of the caste and class in India. I hope this lecture is useful for you. Thank you and have a nice day.